Hello, this is Dr. Janine Santelli. I'm the Executive Director for the American Nurses Association, and I welcome you to our webinar on nurses, caregivers, not criminals. Our presenters are Dr. Marilyn Dollinger and the Honorable Richard A. Dollinger. Dr. Dollinger is the President of the American Nurses Association, New York, and a professor at the Wegman School of Nursing at St. John Fisher College in Rochester, New York. She is active as a policy and political advocate for healthcare issues and for the nursing profession. The Honorable Richard A. Dollinger retired in December as a member of the New York State Court of Claims and acting Supreme Court judge. He also served in the New York State Senate for 10 years, where he was an active member on the Senate Health Committee. Dr. Dollinger and Judge Dollinger have taught healthcare delivery systems, health policy, and health law for many years to the master's and doctoral students at Fisher. They used the RaDonda Vaught case study for the graduate students this spring, and that's what they will be discussing this evening.
Thanks, Janine. So Rick and I have used the case study, the RaDonda Vaught case study, as mentioned in our course. And I believe this is very time sensitive. So we wanted to make sure that we produced some materials that were accurate, fact-based, and dealt with the whole story, the RaDonda Vaught story from beginning to end. So we have prepared this presentation to be used by certainly nurses in practice so that they can learn the details about this case, discuss the possible implications, and hopefully as well for nursing faculty so that they can use this case study for students at all levels so that they better understand what happened in this particular case, understand a little bit about malpractice, about standards of care, and some of the very important messages we have for nurses at all levels to protect themselves from being involved in situations like this. These are our learning outcomes. Basically, the RaDonda Vaught case, which we'll discuss, is a very, very troubling trend of moving professional negligence or malpractice into prosecution in the criminal courts. And we really want to make sure that nurses understand that they need their own malpractice insurance and also representation if they're discussing any of the facts of any situation they're involved in. Here are the learning objectives. You can read through these. We will be doing a detailed timeline, which was available in the Tennessean, which is the newspaper in Tennessee where this event occurred. And it's very detailed. I do have the citations, the references at the end that you can access if you want to. All right, so let's start at the beginning with the timeline of this very, very unfortunate case. On December 26, 2017, Nurse RaDonda Vaught, who worked in a neuro-intensive care unit at the Vanderbilt Medical Center, was called to administer a medication to a patient from the ICU who had been moved down to radiology for a PET scan. She accessed the medicine on the unit, took it down to where the patient was in radiology and administered the med. It was the wrong medication, and unfortunately, the patient died. The patient, cardiac arrested, respiratory arrested, had to be put on a ventilator and died within the next 24 to 26 hours. The medical examiner at the hospital filled out the death certificate as death from natural causes. That is from the brain bleeding. She had been originally admitted with a subdural hematoma. About a month later, in January 2018, RaDonda Vaught, the RN who made the med error, was fired from Vanderbilt. In early 2018, the hospital did have a civil settlement with the patient's family with a non-disclosure clause, meaning they were not allowed to discuss this publicly. In May 2018, Vaught was able to find another job in another Nashville hospital where she was working in a non-clinical position as a coordinator. On October 3rd, 2018, someone in the hospital did a whistleblower report to both the state and federal health officials. And that report actually is available if you pull up in the references, the Tennessean news report here. You can actually click on links and read many of these documents that I'm going to be talking about. I did read the report, and it was obviously filled out by somebody within the hospital system who had all of the details of the case. October 23rd, 2018, the Tennessee Board of Health held a hearing for RaDonda Vaught, and they sent her a letter saying the case did not constitute a violation of any statutes, any professional regulations, and therefore did not merit any further action. So the nurse involved who made the med error reasonably concluded that this was done. In October 31st to November 8th in 2018, CMS, after the whistleblower report had been filed, conducted a surprise inspection at Vanderbilt, and they confirmed that the cause of death for this patient was an accidental overdose of vercuronium. The original drug order was for Versed, an IV administration of Versed to calm the patient down while she was undergoing the scan. And RaDonda Vaught pulled the wrong med and administered vercuronium, which led to the her paralysis and eventual respiratory and cardiac arrest. Now we'll discuss that a little bit more later. CMS also threatened to suspend Medicare payments for the Vanderbilt. And as all of you know, if a hospital can no longer get Medicare reimbursements, they might as well close their doors. It's impossible to run a hospital without Medicare payments. In February 4th, 2019, Vaught was arrested on a criminal indictment and charged with reckless homicide and impaired adult abuse. And we'll talk some more about those going forward as well. The next day, February 5th, the Tennessee Board of Licensing for Healthcare Facilities had a meeting where Vanderbilt, the CEO, and other Vanderbilt administrative leadership was there. And the CEO admitted that they did fail to report this patient's death as required, both to the Department of Health and to the Centers for Medicare Services, CMS. They did acknowledge that the hospital's response was very limited. However, they also made public for the first time that a settlement was done with the patient's family. Now, despite those statements by the hospital CEO, the Tennessee board decided to take no action, no disciplinary action at all against the medical center. Now, in August 20th, 2019, at the request of the law enforcement officials, the medical examiner re-looked at the patient's cause of death and changed it from death by natural causes, that is the subdural hematoma, to accidental, being caused by the overdose of vercuronium. September 27th, 2019, there was a second Tennessee Board of Health hearing for nurse RaDonda Vaught, and they reversed their prior decision that basically said no further action was required. And she had that in writing, and actually you can pull up that letter following that link. This time, for the second hearing, they charged her with unprofessional conduct, abandoning a patient who needed care, and failing to maintain an accurate record. Later, in October and November 2019, RaDonda Vaught was facing both a criminal trial that she had been indicted for, as well as a professional discipline hearing in front of the Tennessee Board of Nursing based on the Board of Health's charges of unprofessional conduct and the other ones we discussed. Now, there was some debate back and forth about which of these should proceed first, the criminal trial or the disciplinary hearing. Her legal counsel was concerned that if she underwent the professional licensing hearing first, that testimony would be used in court and perhaps be prejudicial to that process. Both were delayed by the pandemic. December 15th, 2019, the Tennessean, the newspaper I mentioned, completed and published a story on Vanderbilt's handling of this whole incident. And at that point, the patient's grandson made a public statement that he considered the hospital's handling of his grandmother's death to be a cover-up. He was not bound by the non-disclosure agreement with the other family members who were involved in the settlement. So fast forward to last summer, July 23rd, 2021, the Tennessee Board of Nursing got around to doing the disciplinary hearing and revoked RaDonda Vaught's RN license. Jump ahead till this spring, March 21st to the 25th, 2022, the trial started and finished. And the criminal trial ended up with a guilty verdict. However, and we'll discuss this in a little bit more detail later, the original conviction for criminally reckless homicide was changed to criminally negligent homicide. And then she was also convicted of the abuse of an impaired adult. Now, May 13th, just a short time ago, the judge did do the sentencing, and she sentenced her to a program known as judicial diversion, which meant RaDonda Vaught would not have to do any jail time. She would be put on 3 years probation, and her conviction can be expunged after her parole was completed. Subsequently, Kaiser Health Network, part of the Kaiser Family Foundation, put out a report that the state investigators found that Vanderbilt University Medical Center had a heavy burden of responsibility, in quotes, for a grievous drug error that killed the patient in 2017. But they chose to pursue and the penalties and criminal charges only against the nurse and not the hospital itself. So what we're going to do is talk a little bit about the elements of malpractice to give you some background in that, and then we'll apply those to this case. Rick, do you want to go ahead?
Malpractice is negligence by a professional, and that can be any professional, not just nurses, but doctors, lawyers, accountants. It's a breach of the duty that the professional has to a client, a person, in this case, a patient. There are 4 elements of negligence, and it's important to realize that in order for negligence to occur, all 4 of these elements must be present, and they must be proven to the satisfaction of the jury. The first is the concept of duty. And let me have Marilyn describe. Marilyn, when does a nurse's duty to a patient begin?
So for RNs, for frontline providers, when you show up for work and get report on your patient, that starts your duty to your patient. For APRNs and nurses and other types of positions, basically, if you're taking care of a patient who is part of that practice, or admitted to that hospital, and you are responsible for that care is delegated to you, you then have a duty to that patient.
And that's the critical first step, is that without a duty to the patient, negligence can't exist. So it's really the first aspect of a negligence claim that must be present. The second issue is breach of duty. Breach of duty is when the standard of care, the appropriate response of a reasonable person in discharging their duty to a patient or to a client, when they fail to do what a reasonable person would do. Marilyn, just explain that in the context of nurses.
So we're going to talk
All
about
right,
the
we'll
two
talk
different
about that in
standards
just a
minute.
second. The third ingredient is what's called proximate cause. And this is an interesting aspect of the RaDonda Vaught case, because the question was whether the mistake and the error in providing the wrong medication actually caused the patient's death. There was as indicated, as Marilyn pointed out, the original review by the neurologists at the Vanderbilt Medical Center said she died of natural causes. It was only after this had all been exposed that they changed that opinion to accidental. So the proximate cause is whether the harm that's eventually caused is a result of the conduct and the breach of duty by the professional. That's what malpractice is. And then the final issue is harm. Is the harm that is caused a consequence of the breach of duty and the proximate cause of the conduct, and does it actually harm the patient? In this case, the patient dies, and that's the critical fact. That's the harm. But the interesting part about it is this patient was suffering, was in the hospital to start. It's not as though they were run over in the street when they were a healthy person. And that's an issue to be resolved, the amount of damages. Two quick things. One, as I said before, no malpractice without all four elements present and proven. And critically, malpractice, and which is a form of professional negligence, is by definition an unintentional act. This is not something that you intend to do, that you intend to cause harm. This is something that is done because of an error, a misjudgment, or mistake.
All right, so I just want to make sure that you understand the differences when we talk in nursing about standard of care. We think of evidence-based practice, that you are using the best practices based on evidence-based protocols that are widely accepted and recognized. There's a little bit of a difference when people in the legal profession talk about standard of care. And that is defined by what would a reasonably prudent person with similar education and experience do in the same situation. So in this circumstance, what would another nurse with the same education, experience, and background as RaDonda Vaught do if he or she were put in the same situation? So the legal definition does not expect people to be perfect or to make errors. It's holding someone to a reasonable standard that you would expect from other people.
And let me just add one thing. The standard of care is oftentimes in a malpractice action the most highly contested issue, because what appropriate conduct should have been required by the person who's accused of malpractice? This is where we get into the question of experts testifying about what the standard of care was and whether the nurse or the professional breached that standard of care. The issue of standard of care is hotly contested in malpractice actions, and it's most often proven by expert testimony, in cases of nurses, other nurses, APRNs, other people in the profession. That's the way standard of care is resolved in the legal world.
All right, so let's apply those four elements of malpractice to the RaDonda Vaught case. So duty, did RaDonda have a duty to the 75-year-old patient with a subdural hematoma? Yes, she did. RaDonda was a float nurse that day in the neuro ICU. The patient was a patient in the neuro ICU who had been transported to radiology for the PET scan. RaDonda was given the order to go down and administer the medication. So she clearly had a duty to the patient. Was there a breach of duty to the patient? Well, the nurse retrieved the medicine from their automatic dispensing system. Now, as a little bit of background, Vanderbilt admits that for several months they'd been having issues with their medication dispensing system. The medication system was not communicating with their electronic medical record so that the orders could not be verified. And what happened was nurses were consistently doing overrides in this system, which we all know can cause problems. That became, in essence, the standard of care in that situations. It was the usual practice for nurses to continually do overrides so that they could obtain the drugs they needed in a timely way. So RaDonda Vaught tried to retrieve the drug. She put in Versed, nothing came up. So she just typed in VE. And unfortunately, what came up was vercuronium. If she had typed in the generic term, midazolam, for Versed, she would have gotten the correct drug. She did the override, even though a screen came up mentioning that this was a paralyzing agent. She grabbed the drug, took it down to the radiology and administered it. There were a couple of other red flags as well. Versed was a liquid that could have been drawn up in a syringe and administered IV. The vercuronium was a powder and needed to be reconstituted. So there were definitely red flags. She admits that she did not check the label the requisite number of times. In doing that, she grabbed it from the machine, took the orientee that she was working with, went down to radiology, and then her next stop was going to be in the emergency department where she was being asked to do a procedure with another patient. So was there a breach of duty? She did not follow the safe medication administration practices. However, the nurses had been in the habit of doing overrides based on the poorly functioning system. And Vanderbilt also admitted that this had been a problem. Now, damages, were there damages? Yes, the patient suffered brain damage. And eventually the family was called in sometime within the next day. They said goodbye and the patient was taken off the ventilator. Now, as Rick mentioned, proximate cause. Was that dose of vercuronium responsible for her brain damage? Well, again, as a little bit of background, the patient
looks really
had been
interesting,
admitted
Mark,
with a subdural hematoma and was actually improving. And the PET scan was her last procedure to complete before she was going to be discharged. So it's pretty clear that administration of vercuronium, which caused paralysis, and she was not monitored while the scan was being done. So she was both respiratory and cardiac arrested, needed resuscitation and be put on a ventilator. It's pretty clear that the administration of the medication resulted in the damages. So the elements of malpractice are all present. So we're not disputing the fact that malpractice was the process. What we want to talk about was moving the malpractice from the professional process of discipline to the criminal court.
Marilyn, before we go on, I just want to make one critical point. RaDonda Vaught's interaction with this patient was, it appears, only a single incident. She had been told to give this medication to someone who's going to undergo a scan. So she had only reacted this one time with this patient. But what's important to realize is the minute she got the assignment and began to follow the order and had an interaction with the patient, her legal duty to that patient was established. So I think it's important. Sometimes you may assume that you're only responsible for the patients that you've been assigned on your floor. But it can actually, the duty can be created even from a single interaction with someone who puts their health at your control, under your control. That's the duty. There was a breach of that duty, and as Marilyn explained, proximate cause and damages establishing negligence.
All right. So I want Rick to talk a little bit about civil things being dealt with in the civil law versus criminal law.
Here's what we need to do. We need to differentiate between civil actions and criminal actions. Civil actions are actions in which the party who's been harmed is the plaintiff, and they file an action against the parties who have breached their duty and caused harm. But they're called civil actions. The plaintiff, the party bringing the action, is the individual who claims that they were harmed. That's the first differentiation. Two, the burden of proof in a civil case is that the plaintiff, the party who's been harmed, must establish all four of the ingredients of a malpractice action by the preponderance of the evidence, that it's more likely than not that those factors were present at the time of the harm occurring. The result, if it's proven by the preponderance of the evidence, is that the defendants, could be the hospital, could be the nurse, could be anyone else for whom the harm originates, those parties pay money damages to the harmed party. It's really an issue that involves the transfer of money damages to alleviate the harm for the party who's been injured. But you don't go to jail. You simply pay damages. We'll talk about how the insurance industry pays those in a minute. In a criminal case, the parties are different, the proof is different, and the consequences are different. First of all, in a criminal case, the government, the district attorney or the prosecuting attorney, brings a claim against the party who is accused of a crime in the name of the people in the state. It always says the people of the state of New York or the people of the state of Tennessee. The prosecuting party, the plaintiff, is the government, and they're seeking to enforce the criminal statutes that were passed by the legislature. So the plaintiff, the party bringing the action, is different. Secondly, the burden of proof is different. It's not by a preponderance of the evidence. In order to convict someone of a crime, you must prove, the government must prove, all the necessary ingredients of the crime as beyond a reasonable doubt. There's a huge legal debate for centuries about what reasonable doubt is. I'm not going to go into it here, but it's a much higher burden than preponderance of the evidence, because if the state finds you guilty, if the jury of your peers finds you guilty, then the result is you can go to jail, you can be put on probation, or you can pay a fine. In those instances, the government is taking away your liberty interest. They're taking away your right to come and go. And so the burden of proof is higher, the party bringing the action is higher, and the consequences are different. But the criminal action is a much more severe consequence to the party who's been accused of a crime. Those are the differences.
All right, so I want to let you know kind of the end of the story. The sentencing was just May 13th, I believe.
A couple of weeks ago.
So the sentence was that RaDonda Vaught would be eligible for this diversion program that we mentioned earlier on both counts. Now, what's interesting is the original charge was for reckless homicide. And if a jury would have found her guilty of reckless homicide, the assumption would be made that Vaught saw the risk, but disregarded this substantial and unjustifiable risk of harm to the patient, which resulted in death. All right. So reckless homicide is an action where someone fully realizes the risks and chooses to do something anyway. They did not convict her of that. What they actually convicted her on was a lesser charge called criminally negligent homicide. So the jury in this case actually decided that she failed to see the risk for this patient that should have been seen, but it was unintentional. And then the second charge, she was charged and convicted of abuse of an impaired adult. And this relates to the fact that once the medication was given to the patient, it paralyzed her. And she should have monitored the patient, stayed with her, and then been able to assess the distress that she was in and provide the care that was needed. All right, now, as most of you know, if you watch the news reports or get listservs from the national professional organizations and the state organizations, there was a significant amount of advocacy from the different nursing professional groups. The American Nurses Association, along with the Tennessee Nurses Association, issued this joint statement. And you can read through that. The emphasis here on is mistakes happen in healthcare. That's the way it is. And most often there's systems issues, and to criminalize a medical error is going to lead to many, many unintended consequences. ANA New York, we also released a statement, and our emphasis was as well, this was a tragic medication error, but if you move malpractice into the criminal court systems, that the result is going to be nobody's going to be admitting errors, and then our culture of safety is going to be untenable. There also was a statement from the American Hospital Association and the American Organization for Nursing Leadership, and they emphasized the same things as well, mentioning the Institute of Medicine's report that was done back in 2000 to err is human, and saying that we cannot punish our way to safer medical practices. Now, moving this to the criminal courts was really ignoring lessons from the past. It's turning back the clock. Hopefully all of you at some point during your educational process looked at the Institute of Medicine, now called the National Academies of Medicine, their report in 2000 to err is human. And these are some quotes from that report. Human beings in all lines of work make errors. They can be prevented by designing systems that make it hard, basically, for good people to do the wrong thing. All right. And this culture of blame has to be broken down. And this was the beginning of moving the focus away from the individuals who were committing errors and moving them to the systems perspective and doing things like root cause analysis so that gaps in the system could be identified and closed, understanding that we have to, our goal is to make the system as foolproof as we can. This is also what led to the system of having scannable bracelets on the patients and scannable labels on the med packets. So that again, this was another check. And just as a note, Vanderbilt did not use the scannable armbands or medication packages.
Can I just make one other observation, Marilyn? When you change from, when you move into the criminal context and accuse a nurse of a crime in a circumstances like this, the system errors that led to it, as Marilyn described, the failure of the machinery and the failure of to match the electronic medical records with the dispensing system, those systematic gaps are really ignored, and a jury turns its attention and focuses solely on the nurse in this case. And when that happens, it's just not fair. The context of the error and how it arises because of a systematic breakdown, those tend to get ignored, and the consequences of conviction.
So the danger here, of course, we'll say again, is that people are concerned that they're going to be criminally prosecuted for errors, are not going to come forward and report them. And then we're going to have a system where its safety goes just goes out the window. So hopefully many of you have heard about just culture. And there is a great article, and the link is there, where a just culture analysis is done on this case specifically. But just culture talks about a fair and consistent environment where open communication, transparency, and voluntary error reporting, information sharing, and a willingness to do the right thing is how the standard of care, and that is how business is done. And there is an algorithm that we're going to look at in a minute that looks at the behavior of the individuals who make the errors as part of the process. So this is the just culture framework. The first one you'll see here is human error. And I would propose that this is most often where malpractice occurs. These are unintentional errors. And so you manage these through looking at process, procedures, training, the environment, all the types of factors we've been looking at. And if you'll note how the individual who actually did the error is dealt with, is you console that person and let them know that the system is being looked at to ensure that things like this will not happen again. The next level of at-risk behavior is where I think the type of concerns that the jury had in looking at the lowering the conviction from reckless homicide to negligent homicide. And that is that someone doesn't either understand or recognize the risk that's involved in a particular decision. And again, you manage this through looking at how do you incentivize people to do the right thing? How do you make it easy through a systems perspective for people to do the right thing? And, you know, certainly if someone, as the risk goes up, it's important that people have greater responsibility for recognizing that. But here you would coach the individual and help educate them that you may not have been aware of this, but these were the very, very significant factors that you did not understand or did not pay attention to. Again, not consciously ignoring them. And then the third level here is reckless behavior. And this is where an individual makes the choice to disregard the possible harm or the very significant risk factors that may be involved by a particular decision they make. And this is where you need to take significant remedial measures against someone who did this, depending on how reckless the behavior has. Certainly punitive actions and disciplining and sanctioning the individual would be appropriate. So this is the stepped approach that Just Culture promotes in looking at the decision-making process and how that influenced what happened. Now, I know many of you work in healthcare facilities and agencies where Just Culture framework is used and understood, and hopefully this is a concept that we don't lose going forward. So my question is, what's next? Certainly the patient's grandson was calling for some kind of justice for his grandmother, and hopefully moving professional negligence or malpractice from the professional discipline system within a state to the criminal courts is not something that is seen as a precedent for families to do, so that they can in fact get justice for someone, get justice for their loved one who was harmed by someone. We need to make sure that there's a renewed focus on systems, accountability, and the use of Just Culture that we just talked about. And talking about Just Culture, it really is most important in its efficacy for prevention. So first and foremost, Just Culture is about preventing harm. And it's about making sure that systems are in place and that there's managerial responsibility to make sure that the systems are well designed and basically give employees few choices other than good choices to make when interacting with that system. I think it's very, very important that our professional associations across the country, such as ANA New York, are really tuned in to the details of this issue. I've been on some national calls where people from different states have been, there have been comments by their people in law enforcement in that state saying, we've got to look at professional malpractice more carefully and probably prosecute this more often in the criminal courts. That is a very, very troubling trend. And we've got to make sure we're on top of this with our advocacy efforts and meeting and discussing these types of situations with our Board of Nurses, our Office of Professional Discipline, and potentially the Attorney General's office here in New York, and make sure that this is not a trend that starts. Now, these are some of the take-home messages that I think are so important for nurses to know. Everybody, every single nurse, no matter where you work and no matter what your level of practice, RN, APRN, whatever, everybody needs their own individual malpractice insurance. Yes, your employer will tell you, rightfully so, that you are covered under the employer's umbrella policy. But I will tell you from this and many, many cases before that hospitals are not motivated to settle cases to the best interests of an individual nurse. If it's a process where they need to advocate for the health system as opposed to the individual nurse, that is what's going to happen. The other thing is, and you should check with your employer to see if their umbrella coverage for all employers will assist the individual nurse with legal fees if there is an action against that nurse's license. And most often that is not included. Now, ANA New York offers rates from NSO, which is one of the Nurses Services Organization, one of the providers of malpractice insurance, and you can certainly find other providers as well. But it's important to know there are two types of malpractice insurance policies. The first is claims made, and that means your policy has to be in effect not only when the event occurs, but when the lawsuit is filed. And sometimes these lawsuits are filed, as you can see in this case, years after. The other type of policy, now you can buy tail coverage. So if you were to have a claims made policy, leave that job and end your coverage, you can sometimes purchase coverage that will protect you if a lawsuit is brought on something that happened while you were covered for up to 5 years, but that's fairly expensive. The second one, and the preferential kind of policies, is called occurrence policy. And this means that the nurse is covered for any event while the policy is in effect, even if the lawsuit is filed after you stop your coverage with this insurance company. Now, that's going to cost a little bit more money, but it does have a significant benefit for coverage. You will also get coverage for legal counsel. Typically, you want to check with the policy, but typically when you have your own individual malpractice insurance, if you are called to some type of action against your license, some type of disciplinary process, you will have that legal coverage paid for by your carrier. Now, if you're ever notified in any way, either a subpoena or any contact from anybody, that you are going to be involved in a lawsuit or that there is an action against your license, you should, number one, notify your insurance carrier immediately. And what they do is they are on alert and they can begin to look at legal counsel for you. And then the other process that's very, very important is that if you are asked to discuss the circumstances either around something you did or didn't do for a licensure process, or care you did or didn't give that's involved in a lawsuit, you shouldn't talk to anybody about anything unless you have legal counsel present. Now, this means somebody who's familiar with representing healthcare professionals in these types of cases. The only lawyer you may know is the lawyer that closed your house deal. That is not the person you want to get to represent you in this case. So you have to take it very, very seriously. And remember, anything you say, and even what you think might be a casual conversation with a supervisor, with somebody you work with anybody, can and will be used against you in a court of law. So it's really, really important that you have that. Now, I've got a series of references here. I'm just going to flick through quickly, but you can certainly take a look at some of these. So our hope is that in understanding the RaDonda Vaught case and through the discussion of the 4 elements of malpractice, standards of care, and then looking at the need for individual malpractice insurance and legal counsel, you will be better prepared going forward in your practice. And again, as I said at the beginning, we're hoping that this case study can be used for nurses to talk about this among each other. And educators hopefully will use this for discussions with their students at all levels. Now, if there are any questions, we're more than happy to answer those. And Janine, if there's anything in the chat, you can let us know.
There is nothing currently in the chat, Marilyn.
All right. Thank you.
Oh, Tanya's got her hand up.
Okay. Tanya, just go ahead and unmute.
Okay, I'm unmuted. First of all, thank you for doing this. This is actually a topic that I used to do way back years and years ago. I used to do a seminar that was called Charting with the Jury in Mind. And many of the points that you pointed out here, I covered. But one thing that seems to still be prevalent now, as I was trying to address it back in the 70s and the early 80s, is the reluctance of nurses to spend money on their own malpractice insurance. I was stunned when I used to work at New York Cornell Medical Center and you know, and the surrounding facilities. I would often ask the nurses if they have their own malpractice, and they just 100%, oh no, the hospital has me covered. And they just don't understand that the hospital will settle even if it means throwing the nurse under the bus. And this sort of takes me to an incident that I experienced in a particular facility where a nurse had done the same thing, in this case, she had bypassed the safety on a pump. And the dose that she had programmed in was potentially lethal, but because she was having so much trouble, another nurse came in and happened to see what was happening and stopped the whole thing. But here's the process. The order was written by a physician. The pharmacist filled the order, knowing what type of unit it was going to. And when the nurse couldn't figure out how to bypass the pump, she called the pharmacy, and the pharmacist over the phone tutored her through the process of bypassing the pump. When this came to the committee to review this potentially fatal error, after everything was gone over, the question was, what are we going, root cause analysis and everything, what are we going to do to resolve it? And the director of nursing said, well, the nurse is being counseled and re-educated. And everybody nodded their head and said that was great. And then we went on to the next topic, at which point somebody who shall remain nameless nearly jumped out of her chair and said, wait, what about the physician that wrote a wrong order, the pharmacist that filled it, and then the other pharmacist that sight unseen is trying to tutor somebody through bypassing a safety on a machine? It just seems to me that these safeties, and I understand that sometimes you need to bypass them for an emergency or whatever, but when we hang blood, it takes two nurses. And I think we should really require two nurses to bypass a safety on any of these machines. And I know that, many facilities that would be impossible or nearly impossible, but boy, it's just scary what can happen out there. So that's my story.
It is. No, that's a great story. And in the course that we teach that we talked about at the beginning, we use a number of legal case studies. And I can't tell you how many times all of the other healthcare professionals involved who were originally named in the suits are let off of the cases. And it is the poor nurse, either nurse practitioner or RN, who is left holding the bag.
Yeah.
So very, very important points. And that is one of the reasons that we hope that by having students at all levels study this particular case, faculty can review with them the very, very important responsibility or duty, I think, to have their own malpractice insurance. And again, I will just do a little unpaid announcement here. If you join a professional association like ANA New York, that's one of the member benefits is you do get your individual malpractice insurance at a reduced rate. And even if you buy it on your own, It costs usually for most RNs less than $100 a year. Of course, the price goes up for APRNs, as their responsibility increases. But very, very important that nurses know that their individual malpractice is available. The last article on the reference sheet by Balestra about what NPs need to know about malpractice is one of the best articles I've seen in educating nurses about malpractice insurance. So I highly recommend that you take a look at that reference, and you can learn a lot in just a very brief article.
Marilyn, I have two things I want to say in response to Tanya's example. First of all, Maryland has conducted some research and found that a number of the states have laws that are very similar to the statutes in Tennessee that were used to prosecute RaDonda Vaught. So many of the states have jumped into this issue of the impaired or patient and the abuse of the impaired patient. And they've made criminal actions for that conduct. So I'm going to predict that RaDonda Vaught will not be the last person to be charged with these offenses. It's an appealing issue for a prosecuting attorney to defend the impaired or deceased elderly victim of this error. And I think that these prosecutions are going to be far more frequent in the future. Secondly, as nurses move up the professional ladder, as there are more APRNs, more nurses with doctorates, you're going to find that the standard of care gets higher because there's a greater expectation for being able to see risk and analyze risk and to avoid risk and to know the procedures for avoiding risks. What that means is as the education level goes up, as the experience goes up, their standard of care goes up, which means that they're under a higher standard of care, which means it's more likely for them to be subject to malpractice actions or to be likely to be the target of a criminal investigation, both of which become critically important when you consider purchasing malpractice insurance. As you get an advanced degree, you need advanced insurance coverage. It's that simple.
All right. Thank you for your attention, and hopefully this is useful.
Thank you both so much.
Thank you.